If you live in the United States as a green card holder or a naturalized citizen, there is a quiet change happening in 2026 that most people are completely ignoring. It does not cancel your status overnight, but it does decide how closely your file is watched, and that difference matters more than you think. This update is real, confirmed, and already moving through the system. It is not a rumor, it is not a political talking point, and it is not something that only applies to a small group of people. If you are currently living in the United States as a green card holder, an H1B worker, or under DACA protection, this change touches your life directly. Whether you feel it today or not, most people hear the phrase new immigration law and immediately think of extreme outcomes, deportations, bans, cancellations, or sudden loss of status. That reaction is understandable, but it is also inaccurate in this case. What has changed is not the foundation of immigration law, but the way compliance is measured and verified. For years, the immigration system operated in a largely reactive way. If someone violated a rule and got noticed, action followed. If no issue appeared, silence was interpreted as safety. That mental model is outdated. Now, what has changed is not the foundation of immigration law, but the way compliance is measured and verified. For years, the immigration system operated in a largely reactive way. If someone violated a rule and got noticed, action followed. If no issue appeared, silence was interpreted as safety. That mental model is outdated. Now, the new law introduces a more active structure. Instead of waiting for problems, the system now checks alignment between what is on record and what is happening in real life, alignment between your documents and your actions, alignment between intent and behavior. January 30th is not just a date on paper. It marks the point where expectations formally shift. After this date, the system assumes that people are aware of updated requirements. Ignorance does not carry the same weight it once did. This does not mean everyone will be questioned. It means that if you are questioned, the burden of clarity rests more heavily on you. Let's start with green card holders, because this group often feels the most secure and therefore pays the least attention. Permanent residence has always come with conditions, even if they were rarely enforced aggressively. Living primarily in the United States, maintaining financial and legal ties, filing taxes properly, and keeping USCIS records updated were always required. What has changed is how closely those requirements are now connected. Travel history is a major example. Many green card holders travel for long periods, sometimes for family, sometimes for work, sometimes simply out of habit. Before, these trips often passed without scrutiny. Now, extended absences create questions, not automatic penalties, questions. The system wants to see that the United States is still your main home. That intent must be supported by facts. Employment records, lease agreements, tax filings, bank activity, and physical presence all contribute to that picture. Taxes are another area that has gained weight. Filing taxes has always been required, but now it also functions as proof of residence and compliance. Gaps, inconsistencies, or incorrect filings can raise concerns even if there was no malicious intent. Address updates sound minor, but they are one of the most common causes of problems. People move, change apartments, or live temporarily with family. They update their address everywhere except with USCIS. Under a more connected system, mismatched addresses stand out quickly. None of these issues automatically mean loss of status. What they mean is that documentation matters more than explanations. Saying, "I didn't know," or "I didn't think it mattered," is no longer sufficient. The people most affected by this shift are not criminals. They are normal, busy people who assumed permanence meant invisibility. Now, let's talk about H1B workers. This group operates under one of the most document-sensitive visa categories in the system. Even small changes have always required attention, but enforcement was inconsistent. That inconsistency is shrinking. Employers are now under increased responsibility to verify that sponsored workers are still operating under approved conditions. Job title, job duties, salary, and location must match what was submitted. Remote work, role adjustments, and internal transfers that were once overlooked now require proper documentation. For workers, this creates a dependency problem. Your status is tied to your employer's accuracy. Assuming your employer has it covered is risky. You need to understand your own petition. You need to know what was approved. If something changes, even slightly, it needs to be addressed properly. This law does not make H1B workers unsafe. It makes sloppy processes unsafe. DACA recipients face a different kind of pressure. The program continues, but timing has become more critical. Renewals must be submitted early. Delays matter more. Any gap in protection can cause complications that are difficult to reverse. Waiting until the last minute is no longer just stressful. It is dangerous. Preparation is not optional here. It is protective. Across all these groups, the theme is the same. Immigration status is no longer something you set and forget. It is something you maintain actively. This does not mean living in fear. It means living informed. The system is not hunting people who are following the rules. It is filtering for consistency. If your life matches your records, nothing happens. If it does not, questions appear. And questions require answers backed by evidence. People who stay organized, keep records, and act early will move through this period smoothly. People who rely on assumptions may feel sudden pressure. This shift is not emotional, it is administrative. I will continue monitoring official guidance from USCIS and related agencies. As implementation details become clearer, updates will follow. For now, the most important thing you can do is understand that compliance is active now, not passive. Now, let's address the biggest misunderstanding people have about these updates. Many viewers think this is about mass denaturalization or random citizenship stripping. That is lazy thinking. The system does not work like that. Citizenship is still the strongest status under U.S. immigration law. It is not being casually revoked, but, and this is important, it is being reviewed more carefully in specific situations. Denaturalization has always existed. It is not new. What is new is the attention being given to cases where citizenship was obtained using incomplete, false, or misleading information. This does not mean small mistakes. It means material facts that would have changed the outcome if they were known at the time. Examples include undisclosed criminal history, immigration fraud, false claims of residence, or misrepresentation during the naturalization process. These cases were once rare and slow. Now they are processed more efficiently. It means material facts that would have changed the outcome if they were known at the time. Examples include undisclosed criminal history, immigration fraud, false claims of residence, or misrepresentation during the naturalization process. These cases were once rare and slow. Now they are processed more efficiently. This is why you may hear numbers like 200 cases per month. That sounds scary, but context matters. The United States has millions of naturalized citizens. 200 cases is not a wave. It is a targeted review process. The people at risk are not average citizens living normal lives. They are people whose files contain contradictions that were never resolved. If you became a citizen legally, truthfully, and followed the process correctly, this update does not threaten you. If you cut corners or hid information, time does not erase that risk anymore. Now, let's talk about the psychological mistake many immigrants make. They think silence equals safety. No letters, no emails, no calls, so everything must be fine. That assumption worked in the past. It works less now. Systems are more automated, more connected, and more data-driven. Silence no longer means inactive. It means monitoring. This applies to green card holders especially. Many permanent residents believe citizenship is optional. Technically, yes. Strategically, not always. A green card is permission. Citizenship is ownership. With a green card, your status depends on behavior over time. With citizenship, that dependency drops sharply. If you are eligible for citizenship and keep delaying without a reason, that is a choice, but it is not a smart one in the current climate. This does not mean rush blindly. It means evaluate seriously. Another blind spot is relying on social media summaries. Short clips, dramatic headlines, and viral posts often remove nuance. They compress complex rules into fear-based statements that gets views, but it destroys understanding. Immigration law does not change overnight through TikTok. It changes through memos, guidance updates, internal enforcement priorities, and slow administrative shifts. That is what is happening now. Nothing here is sudden. It is cumulative. Now let's talk about money because this is where many people get hurt quietly. Financial records matter more than people think. Taxes, income consistency, and employment history are not just IRS concerns, they are immigration signals. If your tax filings do not match your claimed status, questions arise. If income disappears for long periods without explanation, questions arise. If dependent, addresses, or filing status change frequently, questions arise. This does not mean you must be rich. It means you must be consistent and honest. Cash jobs, unreported income, or creative filing may seem harmless short term. Long term, they weaken your record. For sponsored workers, job stability and compliance are critical. Changing employers without proper transfers, accepting side work, or drifting outside approved job duties increases risk. Again, not because the system is cruel, but because it is literal. It reads forms, not intentions. Now, let's address people waiting on applications. Backlogs are still real. Delays are frustrating, but impatience causes more harm than waiting. Submitting incomplete documents, rushing forms, or copying templates without understanding them creates long-term problems. A denial today is easier to fix than a misrepresentation finding tomorrow. Accuracy beats speed. If you are renewing anything, green card, DHHA, work authorization, submit earlier than you think is necessary. Processing times fluctuate. Buffer time is protection. Let's also be clear about what this update does not do. It does not cancel green cards automatically. It does not revoke citizenship randomly. It does not deport people without process. It does not override courts. What it does is reduce tolerance for inconsistency. That is the shift. If your documents, actions, and records tell the same story, you move quietly through the system. If they tell different stories, attention follows. Many people watching this video are safe but anxious. Anxiety comes from uncertainty, not danger. Information reduces anxiety. The smartest response to this update is boring. Review your records, check your address history, look at your travel patterns, confirm your tax filings, understand your status terms. Boring actions prevent dramatic outcomes. Now, a hard truth, and I am not sugarcoating this. Some people watching already know they cut corners. They are hoping time erased it. Time did not erase it. It just delayed consequences. If that is you, ignoring updates will not help. Professional advice might. This is not about panic. It is about realism. Immigration in 2026 is less forgiving of sloppiness. That is the real headline for everyone else. Life continues normally. You work, you travel, you build your future. You just do it with awareness. This channel, US Money and Move, exists to filter noise from reality, not to scare you, not to comfort you falsely, but to explain what actually matters. If there is a real policy shift, you will hear it here with context. If something is exaggerated online, we will call it out. The goal is not views. The goal is clarity. As more official guidance is released, this topic will evolve. Enforcement priorities change, court rulings shape interpretation, and agencies adjust internally. Stay informed, not obsessed. If this video helped you understand the situation better, that means it did its job. And remember, immigration safety in 2026 is not about hiding. It is about alignment. This shift is not emotional. It is administrative. I will continue monitoring official guidance from USCIS and related agencies. As implementation details become clearer, updates will follow. For now, the most important thing you can do is understand that compliance is active now, not passive.